companies operating in the Commonwealth. And as someone who's worked on visas a bit under this administration from the diplomatic side, I can imagine that you were very, very busy recently. So thank you for joining us, Glen. Over to you.
Thank you, Devin. Good afternoon, everybody. Like Devin said, I'm Glen Krebs. I work at Graydon, Wyatt here in downtown Lexington. We've got offices in Kentucky, Ohio, Tennessee. Yeah, immigration. Just by raise of hand so I get an idea, who regularly deals with immigration here? Does anybody, sponsorships of visas, things like that? Okay, a little bit. So as you've likely seen in the news, immigration is kind of everywhere. There's been a lot of changes recently in immigration law. The second Trump administration has brought a much more concentrated effort to make specific changes in the area of immigration. A lot of those, as you've seen in the news, deal with immigration enforcement. We've seen in Minneapolis, other places, a large increase in immigration enforcement. We have seen audits of I-9s increase. We've seen different things like that increasing across the country. But it's also led to some concrete changes here in the United States, and I just want to talk about a couple of those, because with these changes has come a lot of uncertainty for businesses, individuals. We get calls every single day now concerned about, encounters with CBP at the border, concerned about, additional requests for evidence that we're seeing on immigration cases, things like that. So we'll just talk about a couple of the highlights of the changes. One of the big ones for those dealing with employment law, and I should say that our practice at our law firm is primarily focused on employment and family-based immigration. We do any kind of employment-based visa, H, E, L, you name the letter, we typically handle those types of visas. And also family immigration for marriage, green cards, family-based immigration, things like that we handle. So one of the biggest things that we've seen on the employment side is, for those who do work regularly with visas are probably aware of what's called the H-1B visa. It's one of the most common employment-based visas here in the United States. And about last year, the Trump administration introduced a $100,000 fee for these H-1B visas. It caused a lot of panic right off the bat for employers that regularly use H-1B visas. Luckily, Jody mentioned, we could see a tweet clarifying something, adding a tariff. We're dealing with the same thing in immigration law. We thought that this visa fee was going to apply to every single H-1B applicant. Luckily, press secretary through Twitter clarified for all of us that was not the case. These fees largely apply only to people immigrating from outside the United States. For those inside the United States, if you're hiring a student from a university, somebody who's working at another entity on a different type of non-immigrant visa or H-1B visa, and they're simply changing status in the United States, that $100,000 fee doesn't apply. So that's one thing that we get questions on a lot. Another big change we're seeing, and this impacts companies that don't, directly sponsor visas for their employees, is what's called humanitarian parole and temporary protected status. The Trump administration has come in and started revoking these left and right. Individuals that were allowed into the country on humanitarian parole, specifically Cubans, Haitians, Nicaraguans, and Venezuelans. They've canceled that program, and then temporary protected status, which is a program for individuals that from specific countries that are facing hardships, such as political upheavals, economic issues, natural disasters. There's a program for if they're in the United States, they can remain here and work in the United States. So you may have employees at your entities that on their I-9s, provide their work authorization based on these. The Trump administration has been withdrawing these left and right, like I said, so far for Venezuela, Honduras, Haiti, Burma, Syria, Afghanistan, South Sudan, and Yemen, and we anticipate seeing more and more countries ending this temporary protected status. The reason I say it is because it's important to keep track of any employees that you may have in those specific statuses, because the pattern we've been seeing is the Trump administration revokes it, somebody challenges it, the district courts say, yeah, we're going to let this program keep going, the cancellation is unjust, the program is still necessary, and then the Supreme Court comes in and says, just kidding, no, it's going to be canceled. So our clients' heads are spinning as far as does this person, can they still work? Do they have work authorization? Things like that. Another one is increased screening at the border. We've gotten a lot of calls recently about, visas being denied because somebody's social media profile wasn't made public. Increased vetting of social media, things like that, has increased, as well as USCIS pausing adjudication of applications from 20 plus countries here in the United States while they increase the vetting system. And then the Department of State has stopped issuing immigrant visas in 75 countries now, while the reasoning being that they're trying to increase the screening and vetting process behind all of these applications to ensure that anybody coming to the United States is not a threat, is coming with good intentions. That all being said, our favorite quote right now is the more things change, the more they stay the same, especially for employment-based visas, right? The underlying system of visa sponsorship, things like that, is still in place. We're seeing approvals. We're not seeing, a marked increase in denials necessarily. We're seeing additional requests for evidence. They want more information, but we're still seeing approvals across the board. I know there's a lot of anxiety with a lot of companies, about sponsoring visas, whether they'll be successful. It is still working. The system is still working, and it's actually sometimes faster than it used to be because as what I assume many of the reasons for these changes is to decrease the amount of immigration to the United States. That's sped up the process for a lot of the clients that we've been applying for because there's less applicants. So that's what we're seeing in immigration. So, thank you all.
Very much appreciated, Glenn. So now we're just going to move into the open Q&A session. So if you have a question, please just raise your hand, and whenever I call on you, just do a brief introduction of yourself, your name, and what organization you represent.
I'm John Ferguson, the president of Project International. And Jody, I had kind of a question for what you're working on. So I'm kind of amazed that there hasn't been more pushback from the OEMs, the domestic OEMs and others. Historically they have a little bit of clout in some of this. So are you seeing that they're hesitant to do that, or are they, obviously there's reasons to be hesitant, right? So, but.
I think it depends on the OEM, and I think it depends on the topic. I referenced MEMA as being a very effective trade association right now because I think it's been easier for them because they're representing the suppliers, whereas like the NAM or some of the larger trade associations that include the OEMs have found it harder to find consensus. Surprisingly, there are some issues that the OEMs aren't necessarily aligned on. So I think, yeah, it depends on the topic. I think a little bit of a difference currently is that the non-domestic OEMs do have a seat at the table most of the time right now, which during the last administration they did not. The Biden administration pretty much only reached out to the unionized OEMs. So that is a little different now, but not always, because like Project Vault, for example, is one where it's not clear if the non-US headquartered OEMs will get to participate in that or not. So there is still like a divide between what was traditionally the Detroit 3 and the rest of the OEMs, but I think this is a tricky time, right? Nobody really wants to get singled out.
Understandable.
But in USMCA is the other hot topic I think that's really important right now for automotive especially, but for more broadly for manufacturing. But the OEMs don't necessarily all have the same views on USMCA either, because I think it's only 3 of the OEMs that have production facilities in Canada, the US, and Mexico, all 3. So their view is going to be slightly different than the OEMs who are only in the US or maybe only in Mexico, US, or vice versa, Canada, US. So interestingly, there's not as much alignment as you would think.
I think a lot of the OEMs are still having those discussions, but it's more closed door working with Department of Commerce, kind of sway them on how they think that how to understand the legislation that's been passed. So I think they are still having a lot of talks. It may just not be publicly